Remove Judge Aileen Cannon for once and for all. I'm Jessica Denson, and this is Lights On. Jack Smith did not ask the 11th Circuit to remove Judge Cannon when he finally appealed to them last week, asking the three-judge panel to reverse her ludicrous dismissal of the Trump classified documents case. But they have the ability to make that call on their own, and they absolutely should. We're going to go to the source for the authority on this. My guest today heads up Citizens for Responsibility and Ethics in Washington, the nonpartisan watchdog group that just filed an amicus brief with the 11th Circuit calling for Cannon's removal. It is a pleasure, as always, to be joined by Crew's president, Noah Bookbinder. Noah, welcome back to Lights On.
It's always great to be here with you.
Thanks so much, Noah. Tell me, I want to get to the nuts and bolts of this brief, but let's just zoom out for a second. We're finally here. This judge has done so many things in the course of this case, of course, up to and including the most recent unthinkable dismissal of this classified documents case. Can you just give me your thoughts on how we got here?
Yeah, I mean, it's really been this sort of astonishing course of events. And, obviously, I think there was a little bit of trepidation when, the first time anything went before her, it was after the search was done. The FBI did a search. They got all these documents, and Donald Trump's people went to court to try to block the government from using these documents, and then to get what's called a special master, basically an outside expert, to review all the documents before the government could even look at them or do anything with them, which really would have been unprecedented. And it was drawn by Judge Aileen Cannon. I think there was a little bit of consternation because, she was an appointee of Donald Trump. But one thing that we've seen over the last few years is a lot of Republican appointed judges, including a lot of Trump appointed judges, who have actually applied the law and been honorable and held, January 6th defendants to account. So there was no reason to think that that was necessarily going to be a problem. But Judge Cannon, from the beginning, has again and again made extraordinary rulings that have made anyone who is who's familiar with how federal courts work and how criminal cases work, just sort of scratch their heads, regardless of where they were on the political spectrum and regardless of what they thought of this prosecution, because the things she's been doing have been just so outside of what you ever see. That really sort of forms the basis for this conclusion that we ultimately came to.
Noah, those of us who have been tracking this case have been looking for months, I think, for the opening for Jack Smith to finally appeal to the 11th Circuit. I know that she has made so many rulings that almost have been kind of like walking a line or walking the wire. So he didn't quite have that opening. Finally, now he has, but he didn't ask for what you have asked for. Do you think that was the right move for him to not explicitly ask for her removal in his motion or in his appeal?
He's in an impossible situation because it is always rolling the dice when you ask to remove the judge in your case, from the case, because you could win, and then if there's a judge that you feel is being unfair, then you don't have that judge anymore. Or you could lose, and then not only do you have that judge, but you have that judge who's extra mad at you because you just tried to remove them from the case. It's like, it's like the old expression. It's like if you come for the king, you must kill him, right? You can only, and I don't mean to use that. Obviously, no violence or anything like that. Lord knows.
We're using metaphors here.
Metaphors, exactly, which in today's world, we have to be
dangerous, right?
It's very risky for a litigant to try to get rid of a judge. But it's not risky for us coming in from the outside to sort of say what kind of the rest of us are all thinking, because we've all been, watching this judge do what she does in sort of disbelief. At this point, it is, whether it is that she is kind of politically just in Donald Trump's camp, or whether it is, something more benign than that, she has made statements that make it seem like she thinks that it is just a sort of intolerable reputational hit to prosecute a former president, even if it's that and it's less partisan than some people might think. It still puts her in a place where she is clearly biased, or she clearly at least appears to be biased. And, observers of this case, really can't reasonably think that there's going to be a fair hearing going forward.
Well, you're very generous in that latter rationale, Noah. I went over your brief, which you filed together with Nancy Gertner, a retired U.S. District Court judge, Stephen Gillers, emeritus professor of law at the New York University of Law, and James Sample, who is a leading authority on judicial conduct and ethics. And I followed through. And by the way, the thing about the Trump legal era is that everything is written for public consumption. Your amicus brief certainly falls into that category. I'd highly recommend that anybody check it out and read it in full at citizensforethics.org. But you give these 3 points. One is the special master controversy, which, as you mentioned, Judge Cannon was already slapped down on by this very 11th Circuit that this case is being appealed to back in 2022. Number 2, you talk about her inexplicable call for jury instructions on a spurious legal defense that would have gutted the government's case had it ever gone to trial. Now, I remember this from a few months back. Hopefully you can refresh our memories on it. And then third, her failure, of course, over the year that she's had this case to move it forward in any significant way until Justice Thomas gave her that one line, excuse she was looking for in that obscene presidential immunity ruling to throw this case out altogether based on this non-existent precedent that special prosecutors have no authority. So can you just kind of run through those, maybe especially the latter 2 rationale, and why it's so vital that the 11th Circuit consider these and remove her from the case?
Yeah, absolutely. And just to note on the first one that, not only was she reversed by the 11th Circuit, and, judges get reversed all the time and good judges get reversed, but she was reversed in some of the strongest terms I've ever seen, where they essentially, said that if what Judge Cannon had done was correct, it would, if it was allowed to stand, it would, it would gut our system of checks and balances. It would tremendously undercut the operation of our legal system. So, they didn't just say she was wrong. They said she was doing something that was fundamentally at odds with how the law works in America. So that's the first part. The second part is on the jury instructions, and what Donald Trump has said consistently, and what his legal team came in and said, is essentially, as president, there's a real law, and it's a law that we've sued on, that we've used to try to ensure that records were being maintained, called the Presidential Records Act. Donald Trump sort of misreading this to say essentially that a president can at any time declare anything that was classified to not be classified anymore. So he could kind of just, standing there say, I'm the president, these aren't classified. And if that was the case, then, that would be a big problem for the government's prosecution here, because he'd just say, well, I didn't take any classified documents because I just decided they weren't classified anymore. It's an argument that has no real basis in any kind of rational reading of the law. It is, nobody's ever read it that way. The language doesn't support it. The cases don't support it. Even the 11th Circuit, when the special master issue came before them, they didn't handle this issue exactly, but they said some things in their decision there that seemed to make clear that this wasn't a viable approach or a viable defense. But Judge Cannon asked both sides to propose jury instructions for a jury based on the assumption, essentially, that this was a valid defense, and that that if Donald Trump's team could establish that he decided that these weren't classified anymore, then he would be not guilty. It was weird, both because just it's a weird thing to hold, but also nobody was talking about jury instructions. There wasn't there wasn't a jury yet, and so there was no need to even get to this. So the idea that she was jumping over a lot of other issues that were much more pressing, much more based in real law, to get to this kind of bizarre place on this fringe issue that Donald Trump was asserting was really problematic. And ultimately, Jack Smith and his team pushed back very hard. And ultimately, she didn't pursue it, at least in the short term, although it was not at all clear that she wouldn't have picked it back up. So that was a second really serious red flag. And then the other part is that, look, this is ultimately not a very complicated case. He had a bunch of classified documents. He wasn't supposed to have them. They were not kept the way they're supposed to be kept. It's the kind of case that for anybody else would have, I worked on cases like this when I was a prosecutor at the Department of Justice. They tended to move pretty quickly. They were hashed out on, sort of a few factual questions. And yet over, a year, she failed to get through basic motions, to make the kinds of decisions that needed to be made to keep this case moving forward at all. She got rid of an original trial date. She didn't schedule another. It was a little bit hard to tell ultimately whether she was just completely in over her head and just not competent to get this done, or whether she was intentionally delaying this. We all know that if Donald Trump becomes president again, he is very likely to use his powers as president to make this case go away, whether it's by pardoning himself or by instructing the Department of Justice to get rid of the case. And so time actually mattered here. And, so if she was, for whatever reason, trying to move this case in favor of Donald Trump, delaying it, and we know delay is his favorite litigation tactic, that was a key way to do it. And she was, she was being very effective, not at anything else, but she was being very effective at delaying this case. So that's the other piece that even going into this really disastrous and kind of wrong-headed decision about whether the special counsel was properly in place, showed that this was a judge who was not the right judge to be overseeing this case.
Yeah, what an understatement. Noah, as you're talking about this, I'm thinking about not only is it an incredibly simple case or relatively simple, but it has enormous implications for national security. And I'm sure that you, as a former federal prosecutor, can relate to other cases of this severity where they would not have been slow rolled like this, and the defendant would have been held in pretrial detention. I think we've had other examples of, people who have had very, much smaller indictments on issues of classified documents and not gotten this kind of treatment. So just to zoom out here and really see where we are with Donald Trump, defendant Donald Trump, and the preferential treatment he's been given. But, you're talking about the bias of Judge Cannon, the standard for recusal. I remember reading articles going almost a year back to how there were discussions among the senior judges in South Florida, trying to tell this Judge Cannon to recuse herself, to step off this case and hand it to someone else. You cite in your brief the federal statute governing reassignment on remand, 28 U.S.C. 2016, and it provides in part that any appellate court may, quote, remand the cause and require such further proceedings to be had as may be just under the circumstances. You say this language authorizes the appellate courts to reassign a case on remand to a different district court judge where the original judge has, quote, engaged in conduct that gives rise to the appearance of impropriety or a lack of impartiality in the mind of a reasonable member of the public. Noah, this reminds me of so many conversations you and I have had about Supreme Court justices, but the standard is crystal clear here, isn't it? I mean, this is what's in front of the 11th Circuit to do.
That's absolutely right. I mean, that statutory language that you read and the case law is very clear that the circuit court can come in here and say that she is biased or has too much of an appearance of bias, and therefore it should go to another judge. And I think it is, and I think one thing that's striking about our brief. I mean, I think that we at Crew have shown ourselves to have a great deal of credibility in the kinds of cases we make and legal arguments we make. But it's not just us here. It is a highly respected former federal district judge who's overseen a large number of criminal cases of all kinds. It's two leading constitutional authorities. These are folks who are looking at this and saying, this is the set of circumstances for which this rule was put in place. It's hard to imagine something more important than this case, as you pointed out. The idea that you had highly classified documents, or documents apparently touching on things like our nuclear program, in places where all kinds of people who not only didn't have the level of classification to look at them, but we know at this point that all kinds of foreign actors and other people with agendas have placed themselves at Mar-a-Lago to try to get access to power. And so, the idea that these kinds of documents could be available to whomever is of tremendous national security importance. So the stakes are very high here, and the judge's behavior in this case is so
mortifying.
Exactly. That, this has to be a case where a circuit court can and should, and we would say must, exercise that power and, bring in, it doesn't have to be a judge that I might agree with politically. It just needs to be a judge who is going to be even-handed and follow the law.
100%. And one of those case laws that you cite repeatedly is Torkington. And I understand there's a test for Torkington. The third factor kind of brought to mind a final question that I want to ask you, which is about timing. And we've basically foreclosed the possibility that this actually goes to trial prior to the election. It's a, crying shame that this has been treated this way. But you quote the Torkington test and you say the gains realized from reassignment would far outweigh any waste and duplication caused by reassignment. So just on a timing factor, can you explain why, any slight delay in reassignment is not an issue here? And can you level set our expectations on what a timeline could look like? Number one, if the 11th Circuit, follows your lead and removes her and Donald Trump is not reelected, and we actually are able to have justice for the American people in this case.
Yeah. So I think it's really important to understand that there's a lot that's been written in this case already. The 11th Circuit has already weighed in twice. There's been a lot of briefing by Jack Smith's team, by Donald Trump's team, and it's also, as I said at the outset, it's not that complicated a case. Obviously, anything with classified documents has some complications, but ultimately, it's a pretty simple case. So another judge could, spend a couple of days reading through those opinions and those briefs and the facts and be ready to go on this case. Obviously, you'd want a judge to be very careful to hear from all the authorities that they need to hear from. But it would set things back very briefly, and then a sort of an objective judge and a good judge would be ready to go very quickly. And Judge Cannon has moved so slowly that I expect you would find with a new judge that it would be a matter of weeks, certainly no more than months, but probably weeks before you saw this case moving well ahead of where it would have moved under Judge Cannon in terms of timing. I think that this case is in a place where, in a matter of a few months, a judge who was really focused on it could dispose of all of the motions before them and set this thing for trial. That this could be ready for trial early next year if the 11th Circuit moves quickly and removes Judge Cannon, puts another judge on the case. This could go to trial early next year. I think we would argue pretty strongly that is what should happen, regardless of who wins the presidential election. Obviously, should Donald Trump become president, he's been pretty clear about his intention to use the Department of Justice in political ways and for his benefit. So I think he might well, we have to assume that he would try to use this to get rid of this case. And I'm sure we would be far from the only ones, will be howling about that and trying to prevent that from happening. But if that's not the world we live in, I do think that this could go to trial in early 2025.
Yes, we absolutely are not judging from ignorance when we make those kinds of guesses. I want to quote just one thing before we let you go, Noah, and that's from your conclusion of this brief, which I think, perfectly put a pin in this matter. It says, although Judge Cannon sometimes has appeared to be forging a parallel universe for former presidents, there is one respect in which Trump's unique status and global visibility ought to influence the reassignment analysis. Those factors arguably make it more important than in any prior case that, quote, justice should not only be done, but should manifestly and undoubtedly be seen to be done. We need to make an example with this case, don't we, Noah?
Absolutely. There is so much skepticism in this country that our system can work, that people can be held to account if they are powerful and wealthy. And so in this case, where we are talking about a former president, a person of immense power, the idea that we can have a case where it transparently looks like he is getting special treatment does just immeasurable damage. And so it's really essential that this case go to a judge who's not going to be biased against Donald Trump, but also not going to be biased for him, and is going to treat him the way any of us would be treated if we were charged with running afoul of the law. We need that for the country, and it has to happen here.
Without fear or favor. Thank you so much, Noah Bookbinder. It's always a pleasure to have you here on Lights On.
Thank you so much for having me.
Of course. As I mentioned, you can check out that full brief at Crew's website, citizensforethics.org. Please subscribe to Lights On with Jessica Denson wherever you get your audio podcasts for special episodes like this and our live episodes on Fridays. And subscribe by subscribing to my YouTube channel, Jessica Denson. Thanks so much.